right, let's get
All
rolling
right.
here.
Well, let's tee it up. Yep.
All right. Deep exhale.
Clap. There we go.
Yep, there we go. 3, 2, 1. Welcome back to Pedaling Squares, where let me start over again. 5, 4, 3, 2, 1. Welcome back to Pedaling Squares Through a Mammal's Life, where we talk about all things bike and endurance sports from a master's athlete's perspective. Viewers and listeners, I'd like to introduce you to Steve Magas, Esquire, attorney at law. Steve is a friend, a collaborator, a colleague, and it seemed right to have him on the podcast during Bike Month. So thanks for coming on, Steve.
Thank you much for having me. I've been looking forward to it.
Yeah, Steve and I just finished an article on comparing 3-foot laws between Ohio and Kentucky for the Cincinnati Bar Association. And then we just gave a presentation on related topics. We call it Bike 101. And it just seemed fitting to follow that up with a podcast discussing some of the same topics for the benefit of our viewers and our listeners. So a little background on Steve. And you can correct anything that I get wrong here, Steve. Steve is a lifetime bike rider. Steve has been practicing law for almost, but not quite, 40 years. That's 4 decades, ladies and gentlemen. There's a lot of experience there. He's handled hundreds of bike cases. He's worked on Ohio legislation. He has been on the board of the League of American, how's it go, Steve? League of American.
It's the Ohio Bicycle Federation is the board. I'm on the board for the Ohio Bicycle Federation, the statewide advocacy group. And then with the League of American Wheelmen, and which is now the League of American Bicyclists, I've been sitting on their legal committee for years. And we haven't done anything in the last few, but we've drafted model legislation over the years, a model cyclist harassment law and a couple other things. So yeah, that's been fun.
Yep. And when he's not practicing law and being a grandpa, he runs a nonprofit, BCRC, that I help him with. That is an acronym for Bicycle Crash Research Center that tracks fatal bike accidents in Ohio. How many years back does that go, Steve?
I've been doing it. I started doing it about a decade ago, and we thought there aren't that, thankfully, bicycle crashes in Ohio that end in fatalities. So we ought to look at every one of them. And so I started trying to do that in real time, where you read about something and then you figure out where did it happen, who did the investigation, go to that police department, get all the public records, do that for every single one for every year, and then look at all the records, put it together and see, are the cops doing a good job? Are they getting the right answers? Are there lessons in these crashes for cyclists or for motorists or for police officers or legislators or city councils, so that because these crashes are the ones that are the most thoroughly investigated. You almost always, 9 times out of 10, 99 times out of 100, you get a good, thorough, deep investigation into a fatality that you don't get into a lesser injury crash.
Yeah.
So,
and we'll
10 years.
And we'll circle back to some of those investigative issues, but since it's on my mind and you're talking about it for the benefit of the viewers. So when you have a fatality and a police department responds, why are they more effectively investigated? And what I'm getting at is, the police showing up with an accident reconstructionist, a survey equipment, that sort of thing. It just help the viewer understand what goes into that type of investigation at that fatality level.
Sure. So in a car crash, a car bus crash, a car bike crash, anytime there's a fatality or very serious injuries, or anytime there is some sort of blatant potential criminality. So somebody's drinking, driving, there's, drag racing going on, somebody's driving without a license. And it's not just your normal accident, cars crash, somebody may get hurt, but not dramatic. So in the big crashes, they investigate them thoroughly because they may prosecute criminally. Smaller crashes, they write a traffic ticket, you pay your fine, and off you go. So, there's certain car crimes in Ohio and in some, but not all states, where you can have a negligent vehicular assault or a negligent vehicular homicide. And that is a criminal case that is a step way above getting a traffic ticket for running into the back of another vehicle. So that's why they are investigated more thoroughly, because there are potential criminal aspects to it. Hit and runs, sometimes they get investigated thoroughly. Sometimes, they just throw their hands up and say, "I'm sorry, nothing we can do," even if somebody was hurt very badly or killed. So that's I starting this 10 years ago. Part of what caused me to do that was I had investigated some crashes where there was almost no investigation, or the investigation was so bad that you kind of wonder what's going on. One of the first fatal bike crashes I handled was back in the 80s. And two younger kids, probably, I think 15 and 10 or 11 or 12, 13, were riding on a country road. The older kid was to the left of the younger kid. The younger kid's on the white line. The older kid's kind of in the middle. Car comes up behind him, and the driver of the car is another kid who plays football with the older kid. So he recognizes the older kid. He says, "Gee, I'm going to give these kids a good scare." Comes roaring up behind him, slams on the horn. The kids freak out. The younger boy goes right into the bushes, and the older boy goes left. So they're going to part to let the car go through, but the car is passing, hits the older boy, slams across the car, goes over the top of the car, and is killed. And the state troopers put the crash together. And how they did that was they put the bike up against the car, and they matched all the little points where the bike and the car hit. And they told the mom, "Well, your son was riding across the road and this car hit him. He shouldn't have been doing that. It was his fault." And they didn't listen to the boy who was trying to tell them the story of what happened. And they didn't really push hard to find out that there was some relationship between the driver and the kid who was killed. So they didn't prosecute. They told the mom it was your son's fault. And so she called me, and I ended up with the case, and I got an expert who looked at the rear wheel of the bike and said, this was not a perpendicular hit. This was a rear end collision. You could see the angle that the bike was when the car hit it because of the way the wheel was dented, and he hit the bike so hard that the bike slammed across to the front of the car and left all those impact points, but it was a rear end hit. And we ended up having to take the case to trial. And after my expert testified, the state trooper recanted and said, "Yeah, I think he's probably right." And then we settled the case.
Yeah.
So that was, an early experience for me in terms of, gee, you can't always just take what these officers say at face value. And you have to really dig into it. And then since the 80s, or whenever that case was in the mid 80s, since that time, we've seen certainly an uptick in riding among younger people and police officers. We see a lot more police officers on bikes. You see mountain bike and bike cops have become kind of a popular thing since that time as well. So there's more awareness within the police community of what it is to ride a bike and what some of the issues are. But that case was a real eye opener for me as to this guy was adamant,
and it kicked off BCRC, but you didn't call it that.
Well, it did.
The Ohio Fatality Project, right?
It took 20 years before I actually started collecting those, but there were, in the process of that, there was one out of Cleveland. There was a 3-page police report, and the sketch, usually you get a fatal crash report, and there is a sketch that's very nicely done with measurements and reference points, and it's just a very complex diagram of the scene. And in this one, this guy was killed. He was 70 something years old. And the sketch looked like, at that point, my grandson, who's 10, was probably 4 or 5. He could have done a better job drawing the diagram from the fatal crash. And they just let it go. And I tried to follow up to see if anyone ever pushed it. Maybe the guy didn't have family. I don't know. But it was just the oddest. There's no witness statements, nothing in writing, just 3 pages. Cyclist screwed up, and it wasn't like the facts were, because when I looked it up, I looked to figure out why was he even on this road. He had come from one road, and when I punched in his address was up a little bit and on the other side of that road. So he came from a road, was only going to be on this strip of road probably for a couple stoplights, and he was going to go home, was my theory. Cops just never looked at that. So that sort of motivates you to really dig into these things and even communicate with the police sometimes if you have to try to push them to get things right. So anyway, that's a long answer to a short question.
Well, and we're going to circle back to some investigative issues at the end of my lightning round of questions. But before we get there, let's talk about how you ended up representing cyclists, because you've made a career out of it for multiple decades now, but you didn't start out that way.
No, I started out as a law clerk in the appellate court. And then after, that's normally considered to be an 18-month, 2-year job, and then you look for something else. So as I was looking, I was living on the west side of Cincinnati, and there was a law firm that I drove by every day on Glenway, and they had a big cube in the front yard that said attorneys at law, and they had a cool house they turned into an office. I said, oh, it's kind of neat. And I stopped in with a resume, and they said, well, gee, you're in luck. We just had a guy leave last week. Let's look at your resume. We talked. I started working there. And at the same time, I was getting back into cycling with the Cincinnati Cycle Club. And so pretty soon after I took that job, there was a blurb in the Bike Club newsletter. It said, help, we need a lawyer. And I called the president and said, what's going on? He said, we're a nonprofit, and the only thing a nonprofit has to do basically to stay a nonprofit is file this piece of paper, 1 page every 5 years. It's called a statement of continuing existence. And you have to tell the state that, yes, we're still here. But if you don't do that, then you can lose your charter. And what happened was the Cincinnati Cycle failed to file their statement of continuing existence for like 20 years. And the state said, when they went to renew their corporate charter, the state said, well, sorry, you can't have that name anymore, Cincinnati Cycle Club, because now we have the Cincinnati Motorcycle Club, and you have to get their permission to use your name. So I figured all that out, and then I looked up the Cincinnati Motorcycle Club, and I learned that the president of that club hung out at a bar on Cheviot in Cheviot called Stormy's. And Stormy's was your prototypical biker bar where the Harleys are lined up out front, boom, 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 every day. And there's a sign on the door that says no colors allowed. And I thought, that seems kind of weird and racist, but I learned later that it had nothing to do with race. It was about gang colors. You weren't allowed to display your gang colors in the bar because that could generate, problems inside the bar. So here's young Steve, 25. Yeah, so it's a 25-year-old Steve in his 3-piece suit and his brand new briefcase goes walking in looking for Butch, the president of the Cincinnati Motorcycle Club, and we chat and he signs off on the forms, and we get the club, the CCC, its name back. I wrote a little bit about that, and then somebody called me with a case, and I helped him out with a case, and I wrote a little bit about that. And then there was a guy who got a DUI on his car, or they got a DUI on his bicycle, but they took away his driver's license because they added 6 points to his license, and that kicked him over the top of the points. Yeah. And so I had to figure that out. We got a court order ordering the state to take those points off his license. So I wrote about that. I got some more cases, and then this fatal crash kind of came in. That was the first really big case I had, and I wrote about that. And for the first 3 decades or so of my practice, the bike stuff was a part of it. I kept growing it, but it wasn't the primary focus. I did all sorts of personal injury cases, wrongful death cases, insurance litigation, some real estate litigation, some probate litigation. And then in 2009, I started my own solo practice. Not sure who was going to call, but it ended up, since then it's been about 85% bicycle crash cases, and 5 or 10% of family members who are involved in car crashes or something like that. But so it's now when I added them up one day, I've had almost 500 bike cases since the 80s, and thousands of other personal injury cases, wrongful death cases. I've had cases in I don't know how many counties, but probably half the counties in Ohio, probably 30, 40 different counties, from here to Cleveland, Toledo, Youngstown, small counties, Mansfield and Columbus. I usually have a half a dozen cases in Columbus at any given time. And I've been all over Ohio on the bike stuff. So fun stuff.
Yeah, let's talk a little bit about riding your bike in Ohio. I want to get into our time machines and head back to 1902, which is a date you should be familiar with, because cyclists prior to 1902 and perhaps currently may take for granted their right to be on roadways. And that was not always enshrined into Ohio law, was it?
No, not at all. In fact, you think back to the 1800s, and the roads were kind of crappy, dirt roads, and mostly horses and wagons, were on the roads. And then the bicycle came along and wasn't, the runaway success story initially, but in the mid to late 1880s, the penny farthing, which is the bike with the big wheel in the front, the tiny one in the back, that was upgraded to what they called the safety bike, which is a bike that has two wheels of the same size. It kind of looks like what you'd ride today, two wheels of the same size with a frame, a handlebars, pedal, chain. And when that bike hit the market in the mid 1880s, the bike boom started, and it carried us for like the next 20 years until cars took over. So by 1902, the bike boom in Ohio, was really big, and it impacted not just people who wanted to ride bikes, but it impacted the way people shopped. It impacted people dressed, and it impacted society. It impacted how people did and how their relationships were formed, because you could go further and you could do different things on a bike, and it became very fashionable societal thing to do if you're a little well-to-do to have, say you had having a Mercedes-Benz car, you had a Columbia bicycle, and you'd spend, your 2 months salary on the bike instead of a car or something. And so by 1902, cars hadn't taken over, bikes were still on the road. And by that point, you could go pretty fast and move pretty quickly on a bike. And this fellow, Mr. Johnson, was zipping along through, I forget what town it happened in, but as he was riding through town, he hit and killed a person. And he was charged with a form of manslaughter. And this particular form of manslaughter required the prosecutor to prove that he was doing something illegal when he committed the crime. And so the question became, what was he doing? He was riding a bike on the road. Well, is that illegal? And there was no book of laws at that point. Nobody had written down a traffic code, to govern horses and bikes by that point. That didn't come along until cars took over. So that when the court looked at that question, they said, there's nothing that prohibits him from riding a bike on the road, and the road is a logical place for him to ride the bike. So the court concluded that it was not illegal to ride the bike on the road, and as a result, he couldn't be prosecuted under that particular statute. But that was the first case in Ohio that talked about bicycles, talked about riding a bike on the road, and confirmed that you could, in fact, legally and lawfully ride your bike on the road. And that was kind of the start of where we are today, where that right of your right to use the roadway, which is a public way, with a bicycle is written into Ohio law very effectively.
It was a dramatic start for Ohio cyclists, that's for sure.
It was a crazy case to start with, but yes, it's very dramatic.
It was very dramatic for Mr. Johnson.
Yeah. Yes.
And I think at the core of that case is this idea that the prosecutor needed an unlawful act. So the inverse of that is if it's not unlawful, it's lawful. And from 1902,
right, or if it hasn't,
yeah. And from 1902 to 2000, yeah, what are we going on here? Do the math for me. We're going on 120 years from that case.
20 years.
Yeah, it's been lawful in Ohio to ride your bike on the roadways. And I want to kind of move forward just a little bit into the passage of the Ohio Revised Code. You don't need to quote it chapter and verse, but when you and I talk about roadways with our clients or roadways during a presentation, that's a defined term under Ohio law, as opposed to just loosely referring to things as streets and avenues and thoroughfares and that sort of thing. So why is it important to talk about the precise definition of a roadway and maybe talk a little bit about some cases that have litigated the roadway and why it's important to kind of break down the dimensions of a roadway and where, because what we're going to evolve into is, or the evolution of the discussion is going to be what's the roadway and where are we allowed to ride on it as Ohio cyclists?
Well, there's a couple big points. Number one, the most important right that you have when you're operating a vehicle on the road is the right of way. And that is a right. It's usually generally thinking, if you think of the parade, the guy in the front of the parade has a right of way, which means that person can go forward. He can travel along the road without interruption by anybody else. He has the right that supersedes the other people from interrupting his flow of traffic. And a bicyclist who's riding lawfully has the same right of way as someone driving a motorcycle or an Amish buggy or a Beetle or a Humvee or a bus or a semi. The right of way is the same. That's your right to move forward without interruption. You have that right when you are on a roadway. And the law of Ohio says that bikes are governed by the same rules of the road when they're being used and operated. Actually, the big law says when you're being operated on a highway, which is interesting. Yeah, because that is, there are two key definitions. A highway is the entire, this is a different use of right of way, but it's entire property right of way from the fence posts over on the one side to the fence posts on the other, and it has the ditch and it has the berm and the shoulder and it has the paved stuff that we think of as the roadway. And the roadway definition is that subset within the highway, and the quote is the portion of highway improved, designed, or ordinarily used for vehicular travel, except it does not include the berm or the shoulder. Unfortunately, those words berm and shoulder are not defined. So when we talk about riding a bike, the bike is sort of a hybrid vehicle. You can't drive your car on the sidewalk, you can't drive your car on the tree lawn, but you can ride your bike on the sidewalk, you can ride your bike on the tree lawn, on the berm, on the shoulder, on the roadway. And so once you, what I would like to say, cross the white line and enter the roadway, you're in the game and you're governed by the rules of the road and you have to follow them. But you also have the benefit of you can own the right of way and have that right to move without any other cars interrupting you. So the motorists like to think that cyclists don't have the right of way, that the cyclists have some duty to get out of the way. And that's not what the law is at all. In fact, it's completely the opposite. The people who are behind the bike rider have a duty to respect the bike rider's right of way and to not shove that person off the road. So that's why this roadway is important. You don't have the right of way if you're on the sidewalk, but you do when you're on the roadway when compared to other cars.
And that's one of our jobs when we get into a courtroom is to take these definitions, roadway, right of way, and apply them more often than not to a personal injury case involving an injured or unfortunately killed cyclist. There's at least one case out there that grapples with this roadway definition, Sec versus Rogers. And if you could just chat a little bit about the background on that case and how it
Well,
fits in.
There's 4 or 5 cases. Is a weird case because it's hard to tell what happened, and they don't go through. When you read a case, they normally follow a pattern where the judge says, "Here's the facts. Here's what happened. Here's what the issue is. Here's the law. Here's how we're applying it to these facts." Well, SEC doesn't really go into the facts, so we're not really sure what happened. There was a trial, and the trial court gave an instruction to the jury with the definition of roadway in it. And the court gave the definition that I gave you before about the ordinarily the space on the road highway, improved, designed, or ordinarily used for vehicular travel, except the berm or shoulder. But then the court added a sentence to the instruction that seemed to say everything that's paved is the roadway. And one side took exception to that because they wanted the instruction to be, no, it's only white line to white line is the roadway. And SEC seemed to say, well, they said there was no reason for us to think that instruction was the reason the case came down the way it did. So they didn't overturn it. They didn't say that was the right instruction. They didn't say it was the wrong instruction. They didn't overturn the case. And the dissent in that case said, look, you idiots, the roadway is white line to white line. That's what it means. And that's what they should have said. But he was in the dissent. So you've got this case with this goofy instruction, uses the right stuff, adds some other stuff. And the Supreme Court sort of maybe says that's okay. And then you have a case that comes up where there's a fellow there's a kid on a bicycle and he's riding on the road and there's a school bus coming up behind him. The kid goes to the right of the white line. So now he's off the side a little bit. The bus starts to pass him and the kid darts out in front of the bus, gets hit by the bus. The court in that case said the roadway is white line to white line. And when the boy went off the roadway, he no longer had the right of way over the bus. In fact, he had a duty to make sure he could re-enter the roadway, and he had to give, the bus had a superior right of way at that point. If he had stayed on the roadway and the bus had hit him, he would have had the right of way. The bus driver would have been. When he went over the white line and then came back, he had to yield the right of way to the traffic that was on in the lane. And so therefore the cyclist lost. So you think, okay, so it's white line to white line. That's the test. And then the next case to come down was a case where a guy was riding in that same space, but he was going the opposite way of traffic. And he was off the white line. It would be, where you would think the berm would be, but he's riding against traffic. Yeah. And a car comes up from his left, and that car is going to pull onto the road. He rides in front of the car. He thinks he makes eye contact with the driver. The driver doesn't see him and runs him over. And the court in that case said the roadway is not white line to white line. The roadway is all of the paved stuff. So now we got these two cases, both citing the SEC case, but coming to completely different conclusions over what a roadway is. And in both cases, the cyclist loses,
Right. That's the constant.
That's the constant there. So that's part of the issues. There have been a couple other cases that have talked about roadway. We're still trying it out. I think if we had a case that was argued well, briefed well, and the court made a smart decision, I think they would say the roadway is white line to white line. I mean, that's kind of what I suspect. And anything to the right of the white line is not part of the roadway. It's the berm or the shoulder. But but the legislature doesn't define any of that. So you're just winging it. It's kind of squishy.
Yeah. Well, and there's an argument on to defend, which I rarely do, the Ohio legislature. and that a berm or a shoulder should be self-evident. And when you have a definition that spells it out as not quite white line to white line, but where the vehicular travel takes place, everybody knows that's between the white lines, and that's why there's a shoulder, and we're going to exclude it. So what's so hard about that to interpret, judges?
Well, and then the judges in a recent case looked at the Webster's definition in the dictionary, thinking that these words have ordinary meaning. But the judges in another recent case went to the Manual of Uniform Traffic Control Devices, which is the Bible for traffic engineers, and they have a different interpretation. And in fact, in the manual, there is a definition of roadway that implies that cyclists are allowed to ride on the berm and ride on the shoulder. And so that's not explicit in state law either, but that's what a lot of people do. If there's a 4-lane, 55-mile-an-hour roadway and there's a 10-foot patch of asphalt off to the right, most cyclists will ride in that 10-foot patch of asphalt and not go 20 or 25 on a road where traffic may be going 55, but it may be going 75 or 80. So, I think if we had the right case, we could certainly show and get a ruling that cyclists are allowed to ride on the berm or the shoulder. That's not improper, and that they still have some rights as they're riding over there. But the key is this right of way. Can you have the right of way if you're not in the roadway? Probably not a right of way that's superior to other traffic on the roadway.
Right. Yeah. And I guess one of the rubs that you're getting into, that you're touching on, that we're getting into, is this distinction between having a right to be on the roadway, and we'll just call that white line to white line, a right to be on the berm. So you have a right to be present in one of those two locations, but how do you reconcile that right to be there? Not talking about right of way, just the right to be there with, for example, Ohio's AFRAP or 3-foot law. You're measuring if you have to be as far right as practicable, is that directing you into the berm or shoulder to comply with that law? Versus the question of who has the right of way, going into an accident. So maybe help the viewers understand what AFRAP is an acronym for, how it's enshrined in Ohio law, and then these kind of friction points, I call them, in the law.
Yeah, absolutely.
Right of way. You may have a right to be there. That doesn't mean you have the right of way.
Right. And so AFRAP is an acronym. It's universal in the United States. Every state except 2 has some version of a law that says cyclists are allowed to ride on the road, but they have to ride as, AFRAP means as far right as practicable. In Ohio, that is phrased as near to the right side of the roadway as practicable. So the Ohio law recognizes this roadway, and assuming it's white line to white line, you're supposed to ride somewhere in a way that's reasonable over to the right of the lane. So this idea of lane position being dictated is what this AFRAP rule is all about.
And let me stop you there. Because as you're interpreting or offering an interpretation of AFRAP, you've got to tie it, and maybe this is getting too lawyerly on my part, occupational hazard, I suppose. But if the AFRAP statute uses roadway language, isn't the argument that, well, you have to use the definition of the roadway in the revised code, so you do have a right of way within the roadway that then the next step is has a 3-foot buffer from that. So you're not being forced. You're not being forced into the berm or the shoulder.
Right. Yeah, that's right. And I think that is a key point. And the other one, before 2006, we didn't have any definitional teeth in the law as to what practicable meant. I looked it up, that I punched that word in a Google search in Ohio law of all the laws that Ohio has, and it comes up over 250 times, and it's used in terms of timing as near to this time as practicable, as close to this as practicable. And in all those things, what I argued before we had something to yap about under the law, I argued that it had to be as far right as practical, had to have elements of safety in it, and had to have elements of reasonableness from the cyclist's perspective. And so the legislature would not mandate that you have to ride in a way that's dangerous or that you have to ride in a way that's unreasonable. They want you to be. And so I before we had the more recent change, which we'll talk about, I think, I used to bring in an expert to say, this fellow is riding in the middle of the lane. Is that reasonable? Is that safe? Is there a reason why that is a preferred place to ride? And then you would have expert testimony on the fact that, taking the lane, moving into the lane is a smart, intelligent, reasonable, safe thing to do, because the only time these things ever get litigated is when somebody gets hurt. You don't get a ticket for very often for that. So somebody gets hurt, you've got some insurance defense lawyer who's probably reading this stuff for the first time, and he has to ride as close to the white line as possible. And it's
Case
no,
closed.
That's not what the law said. Right, that's not what the law says. And so we would bring in an expert to explain why the lane position chosen by the rider was practicable. And then in 2006, we added a section to that that incorporates reasonable and safe, incorporates some examples of why, parked cars, road hazards, things like that would cause you to ride away from the right side of the road. And then we added the famous too narrow exception.
Yeah, before we get to too narrow.
The lane is too narrow.
Yeah, before we get to too narrow.
Yeah.
Help the viewers understand when a lawyer talks about not necessarily practicable, but reasonableness. The law would imply an analysis under the totality of the circumstances, and so you got to look at the entire package or the entire landscape of what's going on out there, and that is a multivariable analysis that's impossible to write into the law. So the law, the argument would be, not putting words in your mouth, that, practicability kind of equals reasonableness, and reasonableness is the totality of the circumstances. So you have to take into account all the variables that the cyclist was facing immediately before the accident.
Right, absolutely. And what is practicable could change mile by mile by foot based on what you are encountering as a bike rider. That may not present any obstacle at all to a motorist. If a motorist sees a 2x4, they might prefer to go around it, but if they have to go over it, just no big deal. If a cyclist has a 2x4 in front of him, that could be a real problem, or a little pothole, or a patch of rock salt that fell off the truck into a pile that you're going to now slide through on your bike, or whatever it is. There's any number of obstacles, things that provide danger to the cyclist, which to me is why when I argued these cases for cyclists, I have to say to the judge, look, Judge, you have to look at this from the cyclist's perspective, because he's on a very unique vehicle that's different than a motorcycle, different from a car or truck or a bus, and it has different things that can be dangerous to the bike. Cars don't worry about driving in the door zone where somebody might open the door. If you open your car door in front of a Humvee, you're the one who's at risk. If you open your car door into the path of a bicycle, the bicyclist may be killed or injured very badly. So the cyclist, from the cyclist perspective, riding down the road, they can't ride within a foot of a car just to make the motorist behind them happy. They have to get out and make sure nobody's going to be opening a door into their path. So changes your idea of what lane. Another thing I used was, after I started riding motorcycles, there's very good motorcycle training called the Motorcycle Safety Foundation class, and there's a whole book and the techniques that they recommend for lane positioning for motorcycles translates a lot into the world as well. So
well,
there's
let's
some
talk
things there
about
you
that,
can look at.
because cycling advocates will espouse the virtues of, in quotes, taking the lane. So why don't you talk
Right.
to us a little bit about what it means to take the lane in Ohio and how taking the lane is analyzed under Ohio law?
Sure. So under 451155, which is the one of the main laws in Ohio governing cycling, the A section says ride as near to the right side of the roadway as practicable. The B section says you can ride two abreast, and the C section says here's all these exceptions when you don't have to ride as near to the right, including if the lane is too narrow to be shared by a car or a vehicle passing and a rider. And so you look at the lane and the lane width, and virtually every lane in Ohio is too narrow to be shared because 14 foot is sort of the minimum. And even that lane, that width is too narrow to be shared. So virtually every lane that you and I are going to ride on is narrower than 14 foot. So what that means is you can take any lane position you want and be riding lawfully. You don't have to be on the white line or close to the white line. You can take any lane position. So when you're thinking about a lane position and taking the lane, you want to do a couple things. You want to make yourself conspicuous to everybody. If you ride on the white line, you might be thinking to yourself, gee, I'm going to let all these cars pass me. I don't want to hold them up. So I'm going to be courteous and ride way over here. What happens is you tend to blend in to the side of the road. Number one, so people coming up behind you may not even appreciate that you're there. People who are coming towards you that want to turn left are looking for big box-like things in the middle of the lane. They may not see you coming, and they'll see you, but they may not perceive you in their brains as somebody that's in their way. Whereas if you move into the lane, you're more visible earlier to traffic coming from behind, and you're more conspicuous to traffic coming towards you. People pulling out from left or right are also going to be more likely to see you in the middle lane than if you're riding off to the right, where you're trying to be courteous and not holding people up.
And that fits back into that right-of-way
for
discussion we had earlier, where
That's right.
you're in the roadway, so you have the right-of-way, and you're making that more pronounced in the roadway by, in air quotes, taking the lane or riding a third of the way in or halfway in.
Right. Whatever comfortable with. But the other thing that a far to the right lane position does is it sends a visual cue to people coming behind you, and the cue that you're sending them is, gee, if I get close to that rider, I pass that rider and keep my car in the lane, and I don't have to leave the lane. And so they'll, even if they break your elbow, they feel good about that because they didn't leave the lane. Whereas once you move to a more center lane position, I used to use an example. It's like there's a sheet of glass at the lane line, and once they break that pane of glass, they generally give you enough room and they go around you safely. And you have to force them to do that by moving into the lane. So they're either going to run you over, or they'll break over to the left. And once they leave that lane, they'll give you enough room typically to pass. They may get mad at you,
right?
And you yell at you, but I'd much rather have somebody who sees me, is upset, and then yells at me going by than somebody who comes right up on my, says, crap, there's a rider, because I didn't notice you off to the right there. And now they're surprised and they're trying to take emergency action. So.
Yeah, and I guess looking at it from a cyclist's perspective, one of the things that I'm always thinking about when I'm on my bike is, or it doesn't have to be me. It could be a hypothetical person that's out for a Sunday stroll. It's like there's some safety, a sense of safety in being in the berm or in the shoulder. So you want to ride to that right side of the white line because it feels safer, because you're not in the roadway. But the reality is you cross that white line and become part of the vehicular traffic. You afford yourself the legal protections of a right of way, whether a cop or somebody pulling you over for impeding, which we're going to talk about in a few seconds here.
Right.
It is literally safer. And it also affords you a right-of-way right that you don't have when you're riding in the berm or the
Right.
shoulder.
Right. So a perfect example is, let's say you're riding and there's a lot of driveways and somebody's backing out of the driveway. If you are 6 inches into the lane, you're part of the vehicular traffic in the lane. You have the right of way. That person has to stop. They cannot back out in front of you, and they have to respect your right of way. Now, if you're off the road and you're approaching, you're both in sort of an equal plane at that point. You know, you don't necessarily have to keep going while that guy's backing out. If he beats you to the spot, you know, he probably has a right of way over you do. And so there's because neither of you are on the road at that point, and so you may not have the same rights. That hasn't been litigated, but logically thinking,
Yeah,
you know, there's some sense to that. So having said that, I've settled cases like that where the insurance folks haven't thought that angle through, and they just pay the claim. I had another case, a big case, where a guy was on Tylersville Road, which is a big, you know, wide, is 45 to 50 mile an hour road, 65 or 70, and he's riding on a pretty good stretch of berm, 7 or 8 foot wide, to the right of the white line. And there is a road coming up on his right, just a little street, and the white line actually ends before that street. So as he's approaching that street, a young lady is coming on the road. She is A, late, B, realizes suddenly that she's supposed to be back there, so she's going to turn around and make a U-turn and go back the other way. She sees my client ride, and she writes in the police report, "I underestimated his speed." She then makes a right turn as he's coming. He hits the side of the car, goes down, fractured hip surgery, $100,000 surgery. Hip surgery doesn't work. He has to have a hip replacement, $100,000 surgery. And, you know, so all of a sudden we're into a big deal. And the police came and said he was on the berm, therefore he didn't have the right of way. He should have gone over to the crosswalk and walked his bike across. He should not have gone from where he was to do that. Of course, the insurance company jumped on that, refused to pay, and then 2 years into litigation. And if I had a slide, I could show you, but when I looked at the aerial view, we figured out that white line stopped and the roadway was actually all that stuff that was in there. When he got hit, he was in the middle of the intersection on the roadway, because that's the place people drove to make turns and come out and all that. So we had a very good argument. We didn't have to test that to get the case settled. So
because in your scenario, the white line,
have a judge roll
where he was hit, there was no white line.
No, it was in the middle of the intersection. Yeah. And where he was hit was in the place where cars went. It's not like he got hit off the road somewhere. He got hit in the roadway where everybody was traveling. So we had the argument. He was there before her. She should have yielded to him. And the fact that she said she saw him and underestimated his speed, that didn't hurt us either. So,
yeah. When I think about taking the lane, just from a kind of a personal perspective on it, I ride with folks that are adamant about taking the lane, and I ride a third of the way out or half of the way out into the lane. And I guess over hundreds of thousands of miles and getting honked at and yelled at, you know, at some point in time, I strike this kind of balance and applying that rule of thumb to, and I do most of my riding on country roads. I don't do a lot of urban riding or semi-urban riding, but I'll ride maybe 12 inches in from the white line if it's a straight, long country road. If I know I'm going into a windy section or I'm going uphill and there's any kind of curve, you know, I'll take 75% of the lane. I'll take 66% of the lane, just because I know I've got to stop the guy from trying to pass me, because I'm by definition going to be slower than him or her. And I know because I can't see what's coming around that corner. They can't see it either. So I'm super aggressive about taking the lane under those circumstances. But I guess the practical realities of being out on country roads logging lots of miles is that you're asking for trouble, right, wrong, or
Well,
indifferent.
that happened a week ago here in Ohio, where
Yeah.
bicyclist was riding a country road, narrow, 2 lanes. He's within the roadway, half a foot off the white line, and a school bus comes up behind him. Cars are coming towards him. The school bus driver decides to, instead of waiting for 3 seconds to let the cars go by, he's going to pass the cyclist as cars are passing him, so he can't leave the lane without hitting those cars. And he ends up hitting the cyclist, and the cyclist goes down and has pretty significant injuries. So, and it's all captured on the school bus camera, which is helpful because otherwise,
helpful and
otherwise he may, well, very, and it,
Yeah.
but otherwise that he might argue, gee, I was way over here, and the guy made a suicide swerve into me. But it's you would expect a professional driver to understand that that was a very stupid thing.
Oh my gosh, yeah, they should be held to a higher standard.
Yeah, they should be indeed, and that's an area where cyclists might feel compelled to stay to the right because there's so much traffic zipping by. You don't want to just create a long line of cars behind you, but by the same token, when cars are coming towards you, is that the time to move over or not? Or it's a tough call when you're out there in the real world.
It is, and I've looked at this obviously from the perspective of the Commonwealth of Kentucky, and it's not like Ohio, and that what I'm about to say isn't enshrined in the Kentucky Revised Code the same, or excuse me, Kentucky Revised Statutes the same way it would be enshrined in the Ohio Revised Code. But the administrative regulations talk very specifically about when you can take a lane. And the language is found in well, I'm not going to read it out, but it's section 7 of the administrative regulations that address cyclists. And it says you can take the lane if it's too narrow, or if it's not, in their language, a shareable lane, and they measure out shareable as 14 feet. And I went and looked in the, and if it's in there, I can't find it. I went into the uniform manual for traffic control devices, is it manual
uniform
form?
traffic
Yeah,
controller.
MUTD. And it doesn't talk about what a shareable lane is. It doesn't offer you a measurement the same way Ohio law does. So, in a case that you might handle, or I might handle, or you tag team, you're getting into what is a shareable lane based upon experts, because you don't have the benefit in Ohio of a 14-foot measurement. Isn't that right?
Yep. Not in Ohio. Some states have added that. I use a graphic from Florida that shows it shows the 14-foot lane. It gives the cyclist 30 or 40 inches. It shows a 3-foot buffer for passing, and it shows an outline of a truck impeding on that 3 foot because can't fit inside a 14-foot lane and share the lane while passing the cyclist at the foot. And that is actually found in the Ohio or the Florida Department of Transportation rules, but not in Ohio, or that it's, so we just have to make the argument. Hopefully someday we can amend the statute.
Right. I mean, there's certain situations where I think about like the difficulty in reducing to words. I mean, this is kind of an esoteric comment I'm about to offer here from a lawyer's perspective, but you have basically 3 different cycling environments that are very different to radically different. There's logging miles on rural roads. Then there's the folks that commute to work that are literally in an urban environment facing a whole host of other dangers, right? And then I'm not going to call it suburban because that's riding in developments, but there's this semi-urban environment where you're in bike lanes, arguably, and bike lanes that has its own host of problems. And it's very difficult to reduce to words the standard for cyclist cyclist motorist interaction in those three different environments in the same set of words that would apply
To each
equally.
one, right?
Yeah, it's super.
Right.
It's a bedeviling exercise.
It's very difficult.
Having said that, sharing a lane, that's not hard. Like, why can't we why can't we pass a law that says a shareable lane is a maximum of 14 feet? That's about all you can fit a car and a cyclist on, or 16 feet.
Well, no, a shareable lane is a minimum of 14, or is more than 14 foot. Yeah.
I mean, that's a no-brainer. That's an instance where you can reduce the shareable portion of the road to a measurement. But we don't have the benefit.
The problem is, part of the problem is our legislature here in Ohio is not what you would call bike friendly. So
right.
In 2006, it was, I think it's the same sort of party control in 2006 as we have today, but it wasn't as aggressively confrontational and advocative as it is today. So they looked at the Ohio Bicycle Federation as sort of the experts in this bike world, and we were able to get this. It was a big bill. We had, lots of different code sections were impacted, and I worked on it with another lawyer who was on the board at the time. And even there, I look back at it now. It's like, why did we write this way? Because
that's all you could get through.
For example, in the AFRAP.
Yeah.
Well, in the AFRAP law, the AFRAP law says ride as near to the right side of the roadway as practicable. And then when we wrote the C section, we used the word edge instead of side. And in hindsight, it's like, boy, that was really stupid, because it implies that the right side means the right edge of the road, and you can ride away from the edge of the road when these things happen. It's like, that's not what we should have tracked the same language.
Yeah.
But now if we try to go back and change it, we're afraid the legislature is going to say, well, gee, why does that say side? You guys should be over on the white line. And
right. You might unravel
it the other way.
Yeah. You're going to unravel the veins that you got. So you live with how it's drafted.
So in hindsight, we'd have written it a little differently, but it's in there now. So it's different than any other state. And it's, I think it's as good as anything else that's out in the other 50 states from an AFRAP perspective. So.
Yeah, and I want to talk about your Seltzer case in a second here. Excuse me, your Seltz. I added Seltzer to his name. Yeah, I want to talk about Steve Seltz in a second here. But there's, as I'm talking out loud, or I'm thinking, that's another one of those friction points in the law where taking the lane is the safest thing to do, but you're in friction with, not in conflict with, but in friction with this idea that you need to ride as far right as is practicable, right? So let's just observe that friction point. We're not going to resolve it in this podcast, but if you are taking the lane or riding in some portion in the roadway to maintain your right of way, you're almost always going to be slower moving than vehicular traffic behind you. So you're going to get into this situation where you are literally impeding traffic, but you also may be exposed or not to a charge of a traffic charge of impeding vehicular traffic behind you. So how does all that play out for an Ohio cyclist? And you know this firsthand from the Steve Seltz case. Okay, friends, my apologies for the jarring transition here. The podcast got a little long in length. It turned out to be a 2-hour interview with Steve, so it made some sense to cut that down into 2 1-hour segments. This seemed like a logical place to stop and then pick up. So we're ending with a discussion of taking the lane, and then we'll pick right up in the next podcast with a discussion of impeding traffic or obstructing traffic, which is the other side of the taking the lane coin. You may find yourself in a situation where a police officer charges you or issues a traffic ticket for impeding, and there is Ohio law on point, and we'll start out right out of the gates with the next episode of the podcast with a discussion of impeding under Ohio law. So please tune in for episode 7, which is really part 2 2 of the Steve Magas interview. Thanks for your time.